Welcome everyone to this Privacy Rules Privacy Espresso episode. My name is Alessandro Di Mattia from Privacy Rules. And today I'm joined by our expert from Philippines, that is Rose Marie King-Dominguez. Rose Marie is a senior partner at the firm CIC Law in Philippines, of course, and she's also a member of the firm's special projects in relation to M&A, investment, and commercial transaction. But in particular, Rose Marie is an expert in telecommunication technology and data, and that's what we are going to discuss about today. In particular, we are going to speak about employee monitoring under COVID and exchange of health data. That is one of the most relevant topics of the moment, I think, not just in Europe, but worldwide. So I'm happy to be with Rose Marie for this reason. So Rose Marie, how are things going there, and what's the regulation and how you are dealing with it?
So thank you, Alessandro, and good day to everyone. I'm very pleased to be serving you with this shot of privacy law espresso from the Philippines for this privacy rules session. So Alessandro, the ongoing COVID-19 health crisis and its impact on local businesses will remain a source of privacy law concerns for the Philippines in 2021. The issues in this area from a workplace perspective have principally been and will continue to be those relating to work from home arrangements and the release of health data of employees. So I want to focus on these issues and hopefully along the way try to give you a bit of an idea of how the Philippine data privacy law works. So getting into it, with businesses closing during the lockdowns, plus the continuing restrictions on the number of personnel who can report back to the workplace, more and more employers are resorting to work from home arrangements. However, these arrangements can trigger privacy law questions, such as the level of monitoring of employees who are based at home. Maybe employers are worried that their personnel are busy with Netflix or NBA highlights instead of work. How can an employer balance its prerogative to check performance and adherence to rules with the right to privacy of employees? So our data privacy regulator, and this is the National Privacy Commission, has advised that yes, employers can check and monitor employees, but it must use less intrusive or less privacy intrusive methods. Companies cannot employ mechanisms that are disproportionate or excessive, such as tracking mouse movements or recording keyboard strokes or having a webcam take pictures of the employees. The question in the title to my talk, which is, can an employer monitor an employee 24/7? Well, obviously the answer is no. At bottom, it is really all about proportionality. And if many of you listening to this talk find that familiar, especially those from the EU jurisdictions, it's because our data privacy statute, and this is the Data Privacy Act enacted in 2012, is modeled after the EU Data Protection Directive. So it shares similar terms, rules, principles with the GDPR. Let me give you a one-sentence summary of the core of the statute. The Philippine DPA regulates the collection and processing of personal data, so that these can only be done if there is a basis for lawful processing, such as the consent of the data subject. They must be in accordance with the principles of proportionality, transparency, and legitimate purpose, and they must observe and respect the rights of a data subject as set out in the DPA. So this brings us to the question of how can the health data of employees, right, be processed? And here, let me focus on the rules under COVID-19 related issuances here in the Philippines. First, an employer can only collect data that is necessary to determine whether the employee is at the risk of infection, right? So an employer can and in fact must take the temperature of the employee, ask the employee about certain symptoms associated with the virus, and all of this should be done before the employee enters the workplace. So if it's determined if the employee is infected or might be infected with the virus, with whom can the employer share this data without the consent of the employee? It can share it with specific health authorities from the Philippine government. And there is no need to get the consent because under the Data Protection Act of the Philippines, one of the available criteria is the performance of legal obligations. And the collection of this kind of data in this kind of health event, like a pandemic, and the giving of it to the health authorities is a legal obligation. Maybe some of you will ask, well, can the employer share it with other employees in the company, right? Now, there are legitimate purposes where that kind of health data and even the identity of the employee could be processed in the organization. But for contact tracing, again, our regulator has said that the identity of the employee cannot be shared with anyone absent the consent of the data subject. So these are the types of issues I think that will persist in the Philippine data privacy law scene, together with those arising from the move towards the digital economy, right, that our country is experiencing, similar to other jurisdictions. I note that the regulator has been very active in issuing rules and advisories to flesh out our statute. So we can expect, I think, more specific compliance regulation and definitely more enforcement. So with that, I complete the serving of Privacy Law Espresso. Alessandro, thank you.
Thank you very much, Rose. That was extremely interesting. And I received a question via personal chat, but it's like, as far as you know, is there any enforcement and penalty that already has been raised from your regulator in this specific field, or the things are still pretty to move, everything to move?
If we're talking about the Data Privacy Act in general, yes, there has already been enforcement. Our sense is that in terms of continuous and regular monitoring, the level is not that high. The regulator typically will become active if there are complaints, if the problem or the violation is something quite controversial or well publicized, right? But definitely there is enforcement for violations relating to COVID-19 issuances. We haven't really seen a lot of action or enforcement action there.
Okay, and which are the sanctions raised for businesses?
Okay, well, our data privacy statute provides for penalties for particular violations, unauthorized processing, if there's a deliberate breach, things of this nature. And the penalties under the law are criminal in nature. So there can be, of course, fine, but there can also be imprisonment. Typically, lately, the NPC or the regulator has really been focusing more on cease and desist orders. So basically telling a violator, you have to stop processing and then seeking remedial action. So this has been more of the approach rather than trying to enforce the more criminal, more heavy penalties under the statute.
But that was really interesting, Rose Marie. So thank you very much for being with us today, and I thank all our listeners, recorded and live with us today for joining us and joining Privacy Rules. And I invite them all to follow us next Thursday for our next Privacy Espresso with our member from Brazil. Thank you again, and I hope to see you all again very, very soon. Bye, everyone.
Thank you.